Good afternoon to everyone, and welcome to the last session of this symposium. It's my pleasure, my honor to pose a few questions to Justice Loh in conversation and to wrap up this session with this session. And perhaps just to start off with the first question, if I could ask you this, Justice Loh, how do you think the SICC has performed so far in the years since its inception?
Yes, thank you. You're making me feel like a schoolboy with his report card. Well, perhaps I should start with the adage that Rome wasn't built in a day. But having said that, we are only just into our 6th year of existence. So far, we've had 69 cases. Yes, 63 were transfer cases, but we have had some fresh filings. By fresh filings, I mean an original filing in the SICC itself. There was 1 in 2018, 4 in 2019, and 1 in 2020. That was our COVID-19 year. And to date, we have 65 written judgments at first instance and another 15 judgments from the Court of Appeal. That makes 80 judgments. So I would say that's quite a respectable body of judicial precedent and jurisprudence from a court that has only entered into its 6th year. Our cases have involved 35 nationalities, ranging from $4.3 million to $1 billion. First instance judgments have been handed down expeditiously, some as fast as 1.5 months after the date of the last hearing. 36 notices of appeal have been filed. 1 was heard on an expedited basis, and the passage of only 36 days from the time the notice of appeal was filed to the written judgment. So I think that's a credible record. And perhaps as an indicator going forward, as of 5th March 2021, we have 88 registered foreign lawyers with us, 22 of which are Queen's Counsel, 2 are senior counsel, 1 is a senior advocate, and there are 6 pending applications. I think that's quite a credible showing for just over 5 years. We've had an important case on an ISDA master agreement that was very well received. We've had a case on cryptocurrency trading platforms and an infrastructure joint venture dispute between Indonesian and Australian parties, where the claim was pleaded to be about $1 billion. So that's my report card. I hope you're satisfied. Is there anything else you want to know?
No, Judge, I think that's a very helpful review. And just thinking myself about the skepticism that was expressed in some quarters when Singapore was starting off with the SICC, I think that is a very good answer to those skepticisms, and it no doubt we'll see those numbers grow. Judge, another question that we had was just looking at how the SICC has been functioning and is functioning. If you had to pick 2 or 3 unique features about the SICC that showcases its strengths, what would those be?
Well, we have quite a few, but let me just say pick 3. I think the first is that we are a national court. So that must make us quite unique with all our coercive powers, but yet we have an international dimension. And I would say it's a true amalgam incorporating all the best features of arbitration and court litigation whilst doing away with or minimizing the greatest drawbacks of either regime. So it's a good amalgam of the best. Secondly, we have really eminent international judges, all of whom have stellar reputations, and they come both from common law and civil law jurisdictions, and they are available to sit and hear a case or an appeal. Let me give you an example. Where else in the world could a litigant have his appeal heard by a sitting Chief Justice, a former Chief Justice of Canada, and a former President of the United Kingdom Supreme Court? What else can you wish for when you have an appeal with these kind of 3 judges to listen to your appeal? Thirdly, for cases where there's no connection with Singapore, we very unusually and unlike other national courts allow foreign counsel to appear with minimal formality and registration, and they can stand up in court and argue their cases. I think those are 3 great strengths. So that's my answer to you.
Judge, just picking up on the second point that you made about the international judges and their eminence, can I ask, how much have you enjoyed working with the international judges in the SICC, and what do you think they've brought to the dispute resolution scene in Singapore?
First of all, it's been an amazing privilege and an opportunity to work with judges from different jurisdictions and legal regimes. I would say these are the top jurists from their different respective countries, great depth of their knowledge in commercial laws, and a wealth of commercial knowledge, and actually they effectively bring to bear all of this into the SICC case they try. So there's a huge amount of cross-fertilization. You have judges who tend to be non-interventionist, like I think I would like you to smile and nod. The Singapore judges who are less interventionist. And we have foreign judges from other common law jurisdictions who are actually very robust in handling how a trial progresses. And they make no secret of counsel whom they think are wasting time with questions that are irrelevant. So you will find that this huge difference in handling of counsel and cases is something we all benefit a huge amount, a lot of cross-fertilization. And I think you should know that every year, as judges of the SICC, we sit down and we actually go through the cases that have been heard. We discuss those cases, we see if it could have been handled better, we see whether something else should have been done, and it's quite transparent and no holds barred kind of discussion. No one's being particularly polite. We also tell of our disappointments because sometimes we adopt certain measures and we find that it has gone awry. The most common being discovery, where you try and allow counsel some leeway and then the whole thing goes out of control. So we do discuss that. We do learn from other people. As I said in the session after lunch, this was something where our civil law judges said, I can't believe you all read all these affidavits telling the same story again and again and again. And they say, why do we have to read all this? Isn't it very inefficient? And then we also have this, also referred to it, the session after lunch break. How come we have the same document in 5 or 6 places? In affidavits, in a core bundle, in the record of the agreed bundle. It says it's all over the place. And why are we looking at the same document again and again? So I would say that there's a tremendous amount of cross-fertilization and learning. But I find it most helpful when I have a case, for example, on US law, and I have a Supreme Court judge from America sitting next to me. And I find that that judge can help a great deal with the submissions on US law. Their input is really very helpful. And we also had a case which was a very strange case. And I don't think I'm talking anything that's secret. It was from Japan. And there were certainly aspects of the case we couldn't understand until the Japanese judge, international judge, explain to us why certain things happened, because that was the culture in Japan. Things like this, I think, bring up the strength of an international panel, just like you would have in an international tribunal, where the parties have arbitrators who are familiar with the culture, familiar with the industry, and familiar with the kind of dispute. So what have they brought to Singapore's dispute resolution? I can only say they brought a richness we would not have had if we only ever had Singapore judges. I'm sure in the future they will help us build up a jurisprudence which will also be richer for their input and with their experience poured into our judgments. Thank you.
Judge, there is a question that's come from one of the participants, and it asks whether the court has added any jurists from Africa, Latin America, or the Caribbean. And I guess if I can add to that, perhaps whether we see ourselves adding from those jurisdictions in the future.
I can't predict, but I can tell you something that I think is no secret. We always do look for judges that we think will add to our strength and that will add to the bench's international outlook. So you notice we started off with 3 civil law judges from Japan, from Austria, and from France. The Austrian judge, unfortunately, felt the call of higher duty and took, I think, office somewhere else, so it was incompatible with her position as a judge. And we've just lost our Japanese judge because he felt he needed to retire. So I certainly tell you that we do look. We do know there's a need to fill up our civil jurisdiction a bit more. In time to come, I think we will have to get judges from Africa, maybe South America, but these are things that take time. There are no disputes in that direction that come here. In time, maybe there will be. So we are always conscious and thinking of that. Where else do we need judges from? You notice recently we've added India. Justice Sikri has come on board. So I have no doubt that we will strengthen our bench as time goes on the need as we see it going forward.
Thank you, Judge. Another interesting question we've received is about the trial process. And the question is, how do you think the SICC trial process involving 3 judges at first instance, how does that help in dealing with complex cases?
I think it does help. I can tell you, sitting as a judge at first instance, it is, in a very complex case, very lonely to be sitting there by yourself. And sometimes if there are 3 or 4 parties before you, having very able counsel, pushing all their points up there. And in fact, that is what you find in arbitration. If the 3 of us go and sit and have lunch quietly in our chambers, we discuss the case. We discuss, what about this point? What about that point someone brought up? And I must admit that sometimes we bring up points that each other doesn't see. And there's a lively debate. So I found that after hearing cases with 2 other judges, I wish all my trials were with 2 other judges, except for the simplest cases.
Thank you, Judge. Can I ask you another question, Judge? The one thing I get asked the most about the SICC is about enforcement. And how easily can an SICC judgment be enforced in a foreign, non-Singaporean jurisdiction as compared to international arbitration, which has the New York Convention? Your thoughts, Judge?
Yes. I don't think I'm biased if I say this. I think this point about the New York Convention is overblown. If a party doesn't want to pay up on an award, there are quite a few cases reported where you can see they're dancing around with other parties on enforcement 5, 6, 10 years later, they're still fighting it out, right? But you see, I think few lawyers will realize that if we go back in time, I would like to say even before my time, and this was pointed out to me by some of the international judges, what started the New York Convention? You're a young man, Cavinder. I'm not sure you know what started the New York Convention. And you need to go back to the Dicey and Morris on the 8th edition in 1949. And you've got to go back to a case called Goddard versus Gray, which can be found in 1870 law reports of the Queen's Bench. And there you will find that the rule there is that even if the foreign judge got the facts wrong, if he got English law wrong, it was still enforceable, unless there was some issue of public policy. That was how strong it was. And it was because of this very strong common law rule that those who engage in arbitration said, wait a minute, a judgment, a money judgment, is enforced so easily abroad. I think we better do something, because at that point in time, the judges viewed international arbitration as some private consensual dispute resolution mechanism, to which you will see from the cases, the early cases, they felt they were free to intervene as they wished. So it's a very different world when you have a money judgment and you go and enforce it around the world. So we go back to Dicey and Morris, Goddard and Gray. If you speak to many common law judges, and these include American judges, they will tell you that as a matter of normal fare, they do enforce money judgments from other countries. They do not allow the parties to have a second go at the facts or the law. And they just simply say, was the defendant served? Did he have notice? There's a judgment. Unless you can tell me it's affected by fraud or public policy within the enforcement jurisdiction, they enforce it as of right, summarily. Now that's common law judgment, an action on the debt, an action on the common law judgment debt. And you'll be surprised. Just leave aside the Hague Convention, the memorandum of enforcement which signed between courts. Let's look to the civil law countries. You'll be surprised to find that Japan enforced the Singapore judgment, even though they had a requirement under their civil procedure rules for reciprocity. We have never enforced the Japanese judgment at that time. But Japan said, looking at Singapore, and from what the plaintiff tells us, there would have been no reason for a Singapore court not to enforce the Japanese judgment, so we will presume reciprocity, and they enforced it. That's a civil law country. In China, there have now been at least 2 to 3 cases where they've enforced our judgments, absent any treaty, absent any memorandum of guidance or agreement to enforce each other's judgments. Nothing. They just went on the fact that was the defendant served? Did he have his chance to come forward to defend it? He didn't defend it. We're not going to look into anything else. And they enforced it. More recently, you'll be surprised, Vietnam did the same. They also enforced a judgment by a Singapore bank against 2 Vietnamese. And I'm told by many other civil law country judges that I know, from Korea, France, Germany, the only 3 or 4 common grounds on which they will not enforce the money judgment is if the defendant didn't have notice of service of proceedings, if there was no due process, if it wasn't a final judgment, in other words, it was subject to appeal, or it was against the public policy of the enforcement country, or it was affected by fraud. Absent these kinds of factors, they are all enforced. A Korean judge has told me, yes, he's done it a few times. There's nothing controversial about that. So it's much stronger than you think. And, sorry, not you, generally the perception. And I think if you look at the SIFOC Memorandum of Guidance for the Enforcement of Money Judgments, you will see these principles all over. Country after country repeats it. The civil law countries have one pattern, the common law countries, similar patterns. And you will find, I think it's much easier to enforce a court judgment than if you sometimes try to enforce an award against a recalcitrant award debtor who is doing his best not to pay. I hope that answers the question.
It does, Judge, and it arms me with much more to say in reply when I'm next asked about the enforceability of SICC judgments. Thank you. One of the sessions we had today dealt with the SICC's new rules, and I wanted to ask you about this exciting development, not so much about the specifics, but what was the thinking behind the revamp?
Right. So I need to draw together a few strands. So the first point was, when we started off the SICC, you will know we had Order 110. I think you had a big hand in it, in getting that drafted, and it was grafted onto our existing civil procedure rules. But as I said, once the court came into being, we had these rules. Every year we met, we discussed our cases, and we were in fact assailed by our civil law brethren and sisters who said, what on earth are you all doing? Why do I have to read through all these affidavits, the repetition, the documents? He said, this doesn't work. It's terrible. If this in our country, we wouldn't allow it. And so it got us thinking, were there other ways to deal with this? We were not afraid to do robust case management. There was one of our early cases where we took over the first case for the SICC. And the first things two senior counsel told us, we are still fighting over the discovery of 2 to 3 million documents. So because we had pre-discussed this, we took great comfort. When I took great comfort because it was a common stand. And I said to the two senior counsel, I said, come on, you're both very experienced lawyers. You know that most cases will turn on one core bundle. It wouldn't be documents in more than one arch lever file. Max complicated files, I give you 2 arch lever files. And that was something I got from people like Lord Justice Michael Carr. He said, nothing turns on 35 bundles. Never, he says. And both senior counsels swallowed hard and they said, we'll go back and discuss this. And so we said, right, we are having the trial in tranches. The first tranche will only deal with this. And you don't need 2 or 3 million documents for that. We just go on your documents you signed first. And that certainly fitted into 1 arch lever file. And that's how we got, because of cross-fertilization, because of discussion, we had the courage to do this. I'm not sure I would have done it if I was sitting alone and without this kind of input. So that's the second part. When our civil judges came and asked us these questions, and then we heard from some other jurisdictions where they control the documents much more carefully, like Australia, we began to wonder if really we had done enough to adopt the best of both worlds, arbitration and litigation. So that was an ongoing thought process. And then the Civil Justice Commission started, and there was, a big revamp of the rules. And we realized that if there was going to be a big revamp of the rules there, we better have our standalone rules. So that's when we started our work. And as I said at the session after lunch, the registry combed through all the rules in the various courts. They combed through all the arbitral rules. And the discussion started. 15 judges and the registry. And we, one by one, we dealt with all these issues. Some of the orders that you will see when it comes out were actually discussed over 2 or 3 sessions because we couldn't agree. There was quite a wide range of views. So that is the kind of background we had. So the push came with the Civil Justice Commission and the new Civil Justice Rules. But we already had thought processes going before that we needed to do something. And I hope people will find this idea of 3-track dispute resolution very helpful. And as you heard from Mr. Nicholas Lingard, that seems to be the way arbitrations are going. So memorials are not something that will be so alien. Because don't forget, many of our international judges are also very active arbitrators.
Yes.
They know exactly what's going on with that kind of system. So that's how we started with this and came up with these rules. We were also very careful, by the way, to have this discussion with the senior counsel, with local lawyers, with foreign lawyers. And so I think we've got a good thing going for us, but time will tell. Yes.
Thank you, Judge. Perhaps just one more question. As now president of the SICC, what's your vision for the SICC and how do you see the future of the SICC?
Actually, I'm not sure how this president title came about. We've always worked in the same way. I was a judge in charge of the SICC. We worked together as a team. I think there was very close consultation between the Chief Justice, myself, and 2 other international judges. We form a kind of working committee or EXCO. So that includes Justice Bernard Eder and Justice Ramsey. So we deal with the day-to-day. And you know, people come up with suggestions. Every year we have our conference for international judges. We have a huge list of action items that come up. We discuss them, we mull over them, we ask the registry to help us with position papers, and then there's quite robust discussion amongst maybe a slightly larger group of judges, and we form a view. So I would say that's how we work. It doesn't work on one person. And if you think of all these wonderful new cutting-edge ideas, you will know it doesn't come from me. There's only one person, as far as I'm concerned, in Singapore who thinks of all these things day and night, and that's our Chief Justice. So he's always challenging us, what about this, what about that, should we do this, should we do that? And that I think is a wonderful thing, because then we all take away, because he has the germ of the idea, and he leaves it with us to run with it. Sometimes we say, I don't think this is a very good idea. Then he says, okay, I agree. Let's drop it. Let's go to the next one. So what is the vision? I think if you look at the figures coming up in the accountants' journals on the amount of infrastructure and contract that's going into Asia, and you see countries like China, India, Indonesia, Thailand, Philippines, all moving up, the middle classes, you've got to fulfill their aspirations. And how do you fulfill the aspirations, say, of Indonesia without huge infrastructure and contracts coming in? So all those will bring a certain percentage of disputes, unfortunately, but that's life, and they have to be resolved. So the question is, how are we going to resolve it for them? Quickly, efficiently, cost-effectively. And so now at the position we are in, if you see us going forward, what can I see on the horizon? Nearer to us now, I think, is we need to think about infrastructure projects and how we handle them, whether we have a dedicated list of judges who can handle it, and how we should handle it. Should we have a more structured approach? For example, having dispute resolution as part of the process. Then a little further down the horizon is something you've just heard from Justice Ramesh and his team, insolvency. I think you will realize that cross-border insolvency is the next thing that's going to happen. And nowadays, insolvency is not in one country, it's all over the place. We've had it before. We've had Lehman Brothers. We've had Hanjin Shipping. And even before that, as courts dealing with Admiralty, you will find that we dealt with it very, I would like to think, sensibly, always deferring to the home jurisdiction where the bankruptcy occurred, and sort of trying to make consistent orders. And you know, from the last session with the Judicial Insolvency Network, we made great strides over that. And as business arises, as business rises in this Asia, I think the disputes will come, insolvencies will come, contractors will go down, and we need to help them. So I think those are the two big targets we see on our radar now, moving forward, and I'm sure we will be able to meet them in due course.
That is an exciting future, Judge. We're almost at the end of our time, and perhaps I can just ask whether you have any closing remarks or comments that you'd like to share with the participants.
Well, I think it's inevitable there will be some competition between courts in different areas, but I think the important thing for us to remember is we're not in competition with one another. We are here to provide a service. So if parties find Singapore a convenient jurisdiction, by all means use us. If you find another country is a more convenient jurisdiction, and that can well happen, for example, one of the parties is a Singapore party, then nobody would like to, the counterparty wouldn't like to have his dispute resolved here, by all means choose another jurisdiction. And I think you will see that two things. One, more and more the international commercial courts are talking to one another. We do meet. We do see issues that need to be ironed out. We do need to see a need for convergence over best practices. And I think it will only be the good for the businessman. Second, the SICC doesn't stand alone. We stand in an ecosystem which is part of the idea of making Singapore a dispute resolution hub. So we don't sit alone. We sit with the SIAC, we sit with the other arbitral institutions, we sit with the SMIC, we sit with the maritime arbitrators, and something that I think we should develop, which I have in fact given talks before to this body, the adjudicatory boards. I think that's very important to manage infrastructure disputes. There are people who are there on the ground, they know the problem, they make a quick decision, abide by it, carry on with the contract, you can fight it later. It's like the International Security of Payment Act. So that's the kind of message I would like to say. We are part of the ecosystem here. We are part of a larger ecosystem of commercial courts. And more you will find the commercial courts cooperating and working together. And I think that's wonderful because there will be convergence. And that's a big plus to businessmen. Yes, thank you.
Thank you, Judge.